Assalamualaikum warahmatullahi wabarakatuh. So this is part 4 of the lecture for the topic illegality. In the previous lecture, part 1, 2 and 3, we discussed thoroughly on all the clauses for section 24, Contracts Act 1950, clause A, B, C, D and E. The last one was E, which is actually on immorality and public policy. Now we have come to the part which is a subtopic actually for the topic illegality. The subtopic is contracts not affected by illegality, despite it looks like it contravenes the law. Okay, but then despite the contravention, the statute itself saved the contract. That's a way. I mean, the contract remains as valid, or there's a way to make it valid. So contracts not affected by illegality, it means when the statute itself saves the contract. And we have the case law to illustrate the rule here. We have the case of Renggama, anak perempuan Renggasami, and Tai Yuk Lai, another 1998. This is High Court decision. So plaintiff was the proprietor of the land, she's the vendor, and defendant was the purchaser, Tai Yuk Lai, and another. What happened? So they entered into the agreement for sale and purchase, and the value of the land was 86,240. And upon execution of the agreement, they entered and they signed the agreement. So the defendants paid the seller, I mean the buyer, the purchaser, paid the deposit of that 40,000 ringgit Malaysia, which is roughly almost half of the purchase price. So the balance sum, 46,000 plus here, the balance sum was to be paid in accordance with the clause 3 of the agreement. So what does it say? Clause 3 provided that the formation of a binding contract depended upon the required approval from the estate land board. So what's the meaning here? It means the contract was made conditional. I mean, if the approval from the estate land board is obtained, then only the contract is considered as binding between them. And later, plaintiff, the vendor, maybe she has change of mind, so she wants to back off from the agreement. So plaintiff later wrote to the defendants, rescinding the agreement, setting aside the agreement, and she wants to return the deposit. What's the basis? What's the ground? That by entering into such agreement, the plaintiff will be violating section 214A of the NLC, National Land Code 1965. So she was saying that, well, our agreements actually contravene section 214A of NLC, so that's why I'm rescinding the contract and returning the deposit to you. So impliedly, she was saying that the agreement contravenes and then it is unenforceable. So what does it say? Section 214A here, it provides that, among other things, inter alia, that no estate land, so obviously the land in question was estate land, no estate land shall be capable of being transferred without the approval of the estate land board. Meaning that here, no transfer can be made unless you obtain the approval from the board. So plaintiff then proceed to file NOS, or originating summons, in the court. So what's the purpose? Okay, she asked, pray for order that the agreement entered into the defendants be declared null and void as it is illegal. So that's the request by the plaintiff. So this is the observation by the court. So the court has to examine the facts here. Was the contract actually illegal or not? Was it enforceable or not here? So the court said that it is a settled law, okay, that a contract which is prohibited by statute does not become void and unenforceable if the statute itself saves the contract, or there are contrary intentions which can reasonably be read from the language of the statute itself. And the court mentioned, okay, the court actually reproduced section 24. So it says that, well, this section 24 does not apply, okay, to such a contract for the obvious reason that the statute itself has saved the contract which was otherwise forbidden. Okay, all right. So, and then the court said, well, clause 3 of the agreement made it clear that the formation of a binding contract of sale of the land depended on obtaining the required approval from the estate land board. So it all depends on whether the approval was obtained or not. You can't really say it was illegal or unenforceable. And then the court said, well, the agreement would be rendered null and void if the approval was not obtained. So it's made conditional. If you get the approval, then there's nothing wrong with the agreement. It's completely legal and enforceable. If you don't get the approval, then only you can actually put a stop to the contract, cannot proceed with the contract. So it's not legal for the plaintiff to back off from the agreement because they have executed the agreement. They entered into the agreement. They agreed to enter into the agreement. So basically, so which part of the contract which saved the agreement? Clause 3 is the one which saved the agreement. There's a way to make it valid. It's enforceable and valid provided the approval was obtained. So now the next part, the last part actually for the topic is effects and remedy. So what's the effects? What happened to the contract which is illegal? So obviously, whatever illegal contract is considered as void. So a void contract is not enforceable, unenforceable, and is very clear from section 24. For remedy, we have section 66 again, 66. Okay, 66. It provides for remedy of restitution to restore, okay, the parties back to their earlier position. I'm referring to section 66 here. Right, it talks about obligations of person who has received advantage under void agreement or contract that becomes void. So the emphasis is on the word void. But if we look closer, actually, there are conditions attached to this remedy. In order for the party to be entitled to this remedy, so the party needs to fulfill these two conditions. Okay, there are two conditions. The first one, okay, this is we extract from the section, okay, the provision. The agreement is discovered to be void. Okay, and another one is the other party has received an advantage. Then only we can restore back the parties to the earlier position. Okay, first it has to be discovered to be void. Okay, let's have a look at the case here. Ahmad bin Udo and Ng Ek Chong. Well, it's quite old case, 1970. Who was defendant? Defendant was the lessor of paddy land and plaintiff was the lessee. So it involves certain list of paddy land here. So this is an appeal against judgment of High Court of Alustar. So High Court actually dismissed the defendant's appeal. Session court. All right, here from session court up to High Court here, because session court ordered the plaintiff for the return, okay, of the rent, okay, which has been paid. Okay, let's have a look at the facts here. Okay, defendants entered into an agreement to lease out their paddy land, okay, 4 years, 1965 up to 1970 for a certain duration here. All right, at an annual rent of 250 ringgit. On the execution of the agreement, and then on the execution of the agreement, receive the 6 years rent in advance amounting to 1,500 ringgit Malaysia. So that's basically they paid everything, the rent in advance, okay, from the year 1965 up to 1970, the number of years here. And then they have a written agreement. The agreement was drafted by a layman and in the colloquial Malay language. This is a simple or plain term here. Okay, no involvement of the lawyers whatsoever. And then in the agreement, it is provided that if the plaintiff should be prevented from cultivating the land, then defendants must return the advance because the rent was made in advance, okay, for the whole duration. And we have section 3 of Paddy Cultivators Control of Rent and Security of Tenure Ordinance 1955. It provides that no tenancy agreement for the cultivation of paddy shall be for a term of less than 1 season or more than 1 year. So minimum is 1 season or cannot exceed a year. Okay, remember the duration is from 1965 to 1970, which is more than a year. So it contravenes, the agreement contravenes section 3. And then furthermore, Section 16 provides that any contravention of any provisions of the ordinance is an offense. So the relevant part of the act here, ordinance here, is Section 3 and Section 16. So when the case was brought to the court, defendants argued that, well, our agreement was void and unenforceable because why? It contravenes, okay, the ordinance just now. And then plaintiff was in pari delicto. What's the meaning? In equal fault. Both are at fault, okay, with the defendants on the ground that the plaintiff based his claim on the said agreement, because plaintiff is asking for a refund here and defendant doesn't want to refund. The defendant said, well, we know, I mean, it contravenes, okay, the ordinance, so how come you ask for the refund? That's basically the argument. So now, what's the real issue in the court, right? Especially when the case went up to appeal. So whether the money paid by the plaintiff to the defendants under the agreement may or may not be recovered. Should we allow the refund or not here? Okay, by the plaintiff under Section 66 of Contracts Act. And then this is the court's observation. The court actually examined all the facts in relation to this case here. So the court said an agreement discovered. So the emphasis is on the word discovered. An agreement discovered to be void is one discovered not to be not enforceable by law. And on the language of the section, the word itself, it will include agreement that was void in the sense from its inception, from the very beginning, as distinct from a contract that becomes void. So there could be two situations, okay? The first one, agreement was void from the very beginning. Okay, another situation, agreement was valid, but later something happens and the agreement, the contract becomes void. So there could be two situations in that particular circumstances in relation to this section. So the court said there may be cases where parties, like this case actually, enter into agreement honestly thinking that it is a perfectly legal agreement, and where one of them sues the other or wants the other to act on it, then only he discovered their agreement actually was void. Remember, it doesn't involve any lawyers. Okay, it just drafted in a simple term and by in colloquial language. Okay, by Malay, I mean by just a layman. Okay. So, and this is the finding by the court. Since the facts and circumstances of the case, I would say this is actually quite exceptional. Okay, proof that the parties were ignorant. Both of them actually ignorant when they signed. Okay, when the agreement was drafted, that they were executing an illegal agreement. So Section 66 of the Contracts Act, Ordinance those days, okay, will apply. So because of that, plaintiff was entitled to the return of his advance. Remember, we have the maxim ex typicosa non orito actio. You can't really go to the court with dirty hands. Okay, you can't really base the cause of action based on illegal basis, illegal agreement. But for this case, okay, when they signed, both of them were honestly thinking that it was valid. Okay, here, right? So that's why the court allow the plaintiff to get back the deposit or the advance, basically the advance rental. So the focus is, okay, when the court scrutinized, okay, the case here, the main focus is whether the party was aware of the illegality or not. Because why? Under Section 66, okay, to obtain remedy of restitution, the party must not be aware of the illegality. That's why you have the term discovered. Okay. So a guilty party to an illegal agreement will not receive any remedy under Section 66. Because why? It just reflects at typical non-orito actio. Okay, you must go to the court with clean hands. What's the meaning of clean hands here in this situation? You are not aware of the illegality. If you are aware, so your hands are dirty. You are no longer, you are not coming with clean hands. You can also read another case in your textbook. Okay, Yip Moy and Chu Chin Hua also discussing on this, on the remedy. Okay, whether the remedy is available to the party or not. We have another case to be discussed as opposed to Ahmad bin Uduh just now, in which the parties were not aware. Okay, that's the finding by the court. So for Tong Fu Ching and others, and Shigenori, oh no, that's Japan, I think, in 1998. So this is appeal case. Both respondent and appellants had testified that the parties had entered into the two agreements separately in order to circumvent the FIC requirements. So when they were in the court, all right, when they were being asked by the counsel, so they testified, they confessed, yes, they actually, the real intention of signing the agreement is to evade, to circumvent, okay, the FIC requirement, Foreign Investment Committee requirement, and the intention, this intention was present throughout the transaction. So the whole agreement actually was tainted with illegality. They were aware of that. Okay. So the court said, as the arrangement between the parties is illegal and the illegality is not only with regards to its performance, but from the very beginning, in its very inception, from the starting point of it. So such arrangement, the whole arrangement is void ab initio. The respondent being a party thereto cannot claim any remedy under this arrangement. So having said so, it is not open to the respondent to revert to his status quo under section 66 as opposed to Ahmad bin Udur, because both of them were not aware. For this one, they were aware of the nature of the illegality. So they cannot really claim the remedy, right, which is provided under section 66, despite the fact that their contract was void. The last part of our topic, illegality, this is part of the remedy actually, which is unique to illegality. Severability, from the word sever, it's not severe, from the word sever, S-E-V-E-R. Sever means divide or break or make separate or cutting, or we cut off, okay, the illegal part, and just the legal part remains. When a contract contains an illegal term, the contract may sever, the contract may use the discretion, okay? May sever the unlawful part of the contract from the lawful part, thus leaving the agreement free of any illegality. So after the severability, so the parties can sue on the agreement unaffected by any illegality. So it depends on the court discretion of the court whether should allow severability or not. We have this case here, Murugesan and Krishnasamy, 1958. It involved toll, okay, the temporary occupation license. So defendant was toll holder and plaintiff was the purchaser. Defendant and plaintiff, they entered into agreements for sale and purchase. Okay, was to be sold here? The right, title, and interest in the said piece of land. The land actually was under toll. Defendant agreed to execute a valid transfer of the land to plaintiff as soon as the collector of land revenue issued titles. Once he got the title, then he will execute valid transfer, whatever relevant documents. And then the agreement also contained the clause to the effect that pending the execution of transfer, the purchaser is to enter into the land and occupy it. Meaning, yeah, before the transfer could be completed, yes, I allow you to occupy the land. Whereas photo land, that one is illegal. You can't do so. So this amount to an attempt to transfer to him, at least, okay, a part of the vendor's right under the toll license, which is against the law. So the court held that this is the principle. Okay, the court just reiterate the rule. It is well settled law that if several distinct promises are made for one and the same lawful consideration, and one or more of these promises is such that the law will not enforce, that will not of itself prevent the rest from being enforceable. So if the law contains many parts and then maybe one of the parts is illegal and it's possible to cut it off, then yes, we can still make it enforceable. It's not really, I mean, the whole thing is not prevented from being enforceable. Okay, so it depends whether you can or you cannot or you can sever. Okay, if you cannot, then the contract is what? If it is possible to sever, okay, then I mean, the party, okay, may reject the bad part and retain the good part. May reject the illegal part and then retain and enforce the legal part, the valid part. And then eventually, this is the finding by the court, okay, as far as the case was concerned just now. The court said, well, actually, the contracts are void by reason of section 57. We are going to learn the topic later. When it become impossible for the defendants to transfer the title of the land. Actually, they enter into the agreement, but later, the transfer cannot be done. Because why? The seller cannot get the title, all right? The state authority refused defendant application to get the title. So, of course, cannot transfer the property. And then if you look closer, okay, it is more, it's not really so much on illegality, but actually it is more relevant to this, to discuss it under section 57 rather than 24. So because of that, okay, the plaintiff was allowed to recover the purchase money in accordance with section 66. So the gist of it is under 57 rather than 24. So the remedy was made available to the party. So can get back the purchase money. All right, we are done with the topic illegality. So altogether, there are 4 parts, okay, of the lecture. So let me just stop share. Okay, thanks a lot for listening. So please make sure that you understand all the parts of the lecture from part 1 until part 4, this part. And then we can discuss it later, okay, for any problem. So with that, thanks a lot. Assalamualaikum warahmatullahi wabarakatuh.